Hi, welcome everyone. My name is Xi Chen. I'm an Assistant Attorney General with the Child Protection Division, and today I'm going to be taking you through the child welfare system in the state of Maine and just kind of going through the basics of child welfare, understanding how the players in the system works, how the legal framework kind of sets the groundwork for kind of everything we do, and then explain how cases develop, how DHHS is involved, and just to go through terminology and explain how the system may appear to people who may not, as we do, live in the system every day and work intimately with the system. I think we can take it a lot for granted. So with that, it'll just be a general kind of overview. There'll be a lot of terminology, a lot of kind of legal specifics, and it's not so much important to remember every key detail. But this video is just really more about making sure that you have the exposure that, hey, I've heard of best interest or termination of parental rights, or I know what a jeopardy hearing may be. So this is hopefully a good resource to you in your work, and we'll just be going through and just doing a generalized overview of the child welfare system in the state of Maine. All right. So just to start, my role as an Assistant Attorney General is to represent Maine DHHS, and specifically within Maine DHHS, the Office of Child and Family Services. And DHHS is a very large organization, a lot of employees, a large mandate within the state of Maine. And so as you can see from this slide, the Office of Child and Family Services itself also has a very large mandate as well. And child welfare, which is the focus of what today's video is going to be about, is only one part of what Office of Child and Family Services, you may also hear OCFS. Fair warning, there will be a lot of acronyms. It can turn into alphabet soup very quickly. So just try to follow along. But I understand that it's a lot of acronyms, especially for someone who may not be familiar with the field. It's a lot of acronyms all at once. So if you hear OCFS, that's Office of Child and Family Services within DHHS. And my role specifically is representing OCFS as they administer Maine's child welfare systems. So that's specifically in terms of cases involving allegations of abuse and neglect of a child. And so we'll talk about that specifically. But just to give you a broader context, OCFS itself also is involved in, as you can see, regulating child care facilities and providers, child care, fostering adoption services, children's behavioral health services is a big issue as well. So there's a lot of responsibilities, but we're going to focus specifically on OCFS as it relates to the child welfare system specifically in this video. Okay. So child protection or child welfare, the two are kind of synonymous in some instances. So you may hear child protection thrown around, you may hear child welfare. Child protection stems from the legal idea that a state has a responsibility to protect its own citizens, and it has a responsibility to essentially act as a parent to children whose parents, for whatever reason, may not or choose not to be acting as a parent themselves. So there's multiple legal frameworks at play here. So first and fundamentally, there's a constitutional right, and you'll hear there's a due process right as well, for parents to be free from government interference in how they raise their children, in having that parent-child relationship. There's a constitutional fundamental right there. And that kind of goes into everything that happens with regards to state interference in that parent-child relationship. So while child protective cases in the court system are considered civil cases, and they're not criminal cases per se, there are a lot of similarities with what may often be thought of as criminal cases, because there are also those constitutional protections. And one of those is, for example, that parents are entitled to legal counsel at the state's expense if they're deemed to be indigent or they can't pay, right? So they have a constitutional right to representation, much like a criminal case. So there's other similarities as well. So it's important to remember that while child protection may be a civil matter, legally speaking, there are often it's overly simplistic, but there are many similarities to criminal proceedings and how they're conducted. So parents have that fundamental and that constitutional right to be free from government interference, absent a compelling reason. But states also have a compelling right to, and a duty and responsibility, really, to protect the most vulnerable citizens of the state, and those are children who often can't protect themselves, don't have the legal means to protect themselves, physically, emotionally, developmentally. They're just the most vulnerable. So from a state's perspective, they're the most vulnerable citizens who need protection. As for the tribes' right, these are for Indian tribes involving Indian children. We'll touch on the Indian Child Welfare Act, which you may hear about later. But that's a specific subset of cases involving Indian children, and there are specific laws tied to that. But it's important to recognize, and I want to highlight this from the beginning, that there have been historical injustices in how the child welfare, child protective system has targeted indigenous populations throughout the years, throughout the decades and centuries. And we'll talk about this at the end of the presentation. But as a result of that, the Indian Child Welfare Act, so again, another acronym, ICWA, if you've heard of that, ICWA is the Indian Child Welfare Act, was enacted to protect the tribe's right to their culture, their children, and really their future. So that's an important consideration when there is a tribe involved or when there is an Indian child involved. And finally, in all of our cases, the child's rights are at play too, as well. Children have a fundamental right to be raised by their own parent. That is the ideal circumstance that we all hope for. But children also have the right to be raised in circumstances free from abuse and neglect. And I apologize if my video seems to be cutting that off. But it's children have a right to be raised in circumstances to be free from abuse and neglect as well. And finally, children have a right to be raised in their own culture and their own customs, or their own practices as well. So there are numerous kind of other factors at play as well, but these are the big factors in terms of, if there's a law or regulation or a policy, or there's, whether something is done, we're usually balancing these various factors and trying to honor the parents' rights, but also make sure that children are safe as well. So in terms of the legal framework, and I'm not going to spend too much time on the specifics, because each of these, you could do dozens of hours of continuing education on. But just in terms of, if you hear about some of this, so CAPTA is the Child Abuse Prevention and Treatment Act, and many of these legislations have been updated throughout the years. So you'll see many updates. So this is a federal law. There are a lot of specifics in there. I'm not going to get into all of them. Same for the Social Security Act, particularly Title 4E deals with funding for the states for kind of foster care and things like that. But what happens is for many of these federal laws, and Family First Prevention Services Act is also federal law, they set many standards, and child protection and child welfare is inherently a state process. So within all 50 states and the territories in the United States as well, child protection is administered by, the state, Maine DHHS or Wisconsin DHHS, take your pick, right? So, but there's a unified standard because the federal statutes set kind of baselines for funding, for getting federal funding for a lot of the services, for foster care reimbursement, for services to children, for things of that nature. So what you'll see is that even though child protection laws are different across every state and jurisdiction, there are a lot of similarities in how these cases are organized, when they're reviewed, certain legal standards, and that is because of many of these federal kind of standards that have been set, even though their child protection is inherently a state business. There are a lot of federal kind of incentives to conform to a set of standards, and so you'll see that in a lot of different states as well, that cases will always be reviewed every 6 months at a minimum. That's one of those things that you'll see that's based on those federal standards. And then finally, just in terms of Maine, our child protection statutes primarily are located in under Title 22, so that's 22 Maine revised statutes annotated. That's section 4001 through about 4090 something, I believe. So those are the sections for the child. Its long term is Child and Family Services and Child Protection Act. What you'll hear a lot is PC cases for a protective custody case. That's one phrase for or a child protective case. Those are other phrases you may hear as well. And I just want to spend a little time going over some terminology, and this is by no means covers all of the terminology, but you'll run into some of these phrases. And again, it's not meant to have you memorize necessarily every phrase here, because we could spend 90 minutes, 2 hours on it, nothing but acronyms. But just to familiarize you with some of these concepts. So these are some common ones. If you hear family team meeting, FTMs, that's just kind of a meeting for DHHS, the parents, maybe the guardians or resource parents, foster care, sometimes the providers of the child, the providers of the parents. So it's really family team meetings for DHHS cases in child welfare, and we'll talk more about what a DHHS case looks like. But family team meetings are kind of a chance for all the parties, everyone involved, to get together and really collaborate on trying to reunify the family and move forward in addressing whatever the issues are that cause DHHS to be involved. You might hear the phrase safety plan or planning for safety, and that's within DHHS, where DHHS may try to work with families to avoid the need to remove a child through court action or through other means like that, if there can be changes to remove a dangerous individual or something like that, whatever the specific threat may be for that child or that family. CACs, you may hear a lot about. Those are children's advocacy centers, and a lot of this people may be familiar with. But they do forensic interviews for children who have been when there's allegations of abuse, physical or sexual. And one thing to note is that CAC interviews, when they're recorded, there are special provisions for confidentiality, and those are highly protected and confidential as well. And a lot of what we're talking about, we'll talk about this later as well, in terms of child welfare, there is a high level of confidentiality for everything that we do. So that's always something to keep in mind. In terms of guardian or caretaker, this may take on several meanings depending on the specific legal nuances. There could be a probate guardianship or a permanency guardianship, and we're not going to get into necessarily all of those specifics. But just to let you know that there are parents, and then there are legal guardians who may or may not be a parent, but may have some legal authority over the child. And caretaker is kind of more just someone who's responsible for a child, like a daycare employee or something, or even a coach on a temporary basis, something like that. Okay, POA, power of attorney, probate code, Title 18C, that's probate court. That may come up because even though we're going to talk about mostly Maine District Court and kind of our work in child protective cases, it's important to note that there are a lot of probate court actions that could involve guardianship of a child and things like that. And again, we're not going to get into all of those possibilities, but just if you've seen that thrown around, so just understand that probate code in Title 18C in the probate court is separate from the Maine District Court, which hears the child protective actions brought by DHHS. Okay, reunification is an important thing. You'll hear that a lot. It's whenever the state removes a child, and there are some very minor few exceptions, but generally speaking, whenever a child is removed from a family, there's a duty for everyone involved, the state and the parent as well, to try to reunify that family, to address what are the issues that cause the child to be unsafe, and to try to remedy those issues and reunify the family. So there's an overarching emphasis on reunification. So we're all here because of child safety. Ultimately, that's why the state becomes involved. But after that point, there is an emphasis on reunification. PPO, so preliminary protection order, jeopardy, TPR, all are legal terminologies that refer to specific legal phases, and we'll get into the specifics. But so PPO is for emergency removals. A jeopardy is kind of the first formal determination of what the abuse or neglect was, or the threat of abuse or neglect. And then TPR, if it reaches that point, is the legal termination of parental rights, where parental rights are finally pretty much irreversibly terminated. So certainly not every case ends up that way, but if a case if reunification is not successful, it can end up in TPR, and we'll talk about how cases go and what a typical case timeline looks like. And then you'll hear about best interest of the child in many contexts. That's a legal standard. It's taken from kind of the divorce statutes originally, in terms of kind of if two parents are having a dispute over a child and custody of the child, what are the various factors that a court is going to consider in allocating that custody or time with parents. But that has expanded to kind of, in terms of best interest of the child in a child welfare proceeding, it's worked into, for instance, termination of parental rights and various other points as well. You may see the phrase GAL, that refers to a guardian ad litem, who is a guardian ad litem is a rostered attorney who is essentially working for the courts to represent the best interest of the child in court proceedings. And so they're not there specifically to represent the child. They don't represent DHHS. They don't represent the parents, but they're essentially an officer of the court who's there to investigate the best interest and represent the best interest of the child. And you may see CASA as well. That's a court-appointed special advocate. That is someone who also has a lot of training. They're not actually an attorney, but they're volunteers who also take that role of representing the best interest of the child in court proceedings. So this is just some of the terminology. Like I said, we could spend hours on all the terminology you'll encounter, but this is just some of the more common ones. So when we're talking about abuse and neglect, and in Maine, a lot of the language will vary with the states, but there's a lot of commonality. So abuse and neglect is pretty common. You may hear the phrase dependency thrown around in certain states. That's very common as well, that they call, instead of a child welfare or child protective matter, they call it a dependency proceeding. But in Maine, the important definition is abuse and neglect, and I've included the legal site down there. And this is, and I've cut out a lot of the definition because it is quite extensive. But essentially, abuse or neglect is defined as a threat to a child's health or welfare by physical, mental, or emotional injury or impairment. And there are a lot of specific examples cited in terms of sexual abuse, truancy. There's a lot of specific legal standards for abuse and neglect. But this general definition is really important. So it's just threat to a child's health or welfare by physical, mental, or emotional injury or impairment. And then the last part is important as well. It's by a person responsible for the child. So it has to be someone responsible for the child. And that's why the state becomes involved, because as you can imagine, children are often injured, physically or mentally by accident, or by random circumstances that are outside of anyone's control. And that's not a case of abuse or neglect, because in those circumstances, there's no person who's responsible for the child who did something or failed to act that caused that injury or that threat of injury, right? So that's the important part of this definition as well, right? So it's when children are threatened and it's caused by either action or inaction of a person who is responsible for the child. So just thinking about how these cases come to the attention of DHHS, it's important to kind of think of it as a funnel of sorts, right? So what we have is, if you think about all of the instances where there's a caregiver who may be abusing a child or neglecting a child, where there's that threat of abuse or neglect, there are a lot of cases that never, unfortunately, come to the attention of DHHS. And that's what we have to recognize right off the bat, is that it's like a funnel, so that as we winnow these cases down, the numbers get drastically smaller and smaller. So the big number here initially is the report of child abuse or neglect. And so that comes in the state of Maine and through pretty much every state. That comes in through the form of a hotline, a specific hotline number that is staffed 24 hours a day, that anyone can call to report whenever they see or hear something that they suspect amounts to child abuse or neglect. So those are the reports of child abuse and neglect, and those go to a centralized office in the state of Maine for all of DHHS. Okay, and so from that point, those reports are screened, and a lot of those reports may be deemed ineligible or inappropriate because there may not be someone who's responsible for a child. It could have just been a child who was injured through an accident that was no one's fault, or something along those lines, or the reports doesn't contain any information that actually amounts to child abuse or neglect, even as alleged. But so some of those are screened out, and then we get to a smaller number of cases. But the ones that are not screened out are set for investigation and assessment. So what that means is that at that point, those cases will be assigned for investigation or assessment at a local DHHS office. And there's 8 offices across the state of Maine, 8 district offices for DHHS. Each of them has an office, OCFS office within there. And so what happens is, those cases that are deemed sufficient for investigation or assessment will be assigned to those OCFS offices, and a child protective caseworker will be investigating those kind of incidents. And then from there, and then as we get to a smaller number of cases, based on those investigations, sometimes, and not always, there is an administrative finding or an administrative action. So that's where DHHS is seeking an administrative action. And it seems like a court hearing, but it's not. So it's an administrative hearing with an administrative hearing officer. It's all within the executive branch. And what that is it's an allegation of abuse or neglect of some sort of a child by someone who is a caretaker for the child, who is someone who is responsible for the child. And so you'll see the phrase substantiated, or there may be an indication, or unsubstantiated. And that just means that the allegations of abuse or neglect are substantiated, so that means they're upheld. They're indicated, or there's an indication, which means they're partially upheld, but it's not as strong as a substantiation. Or it can be unsubstantiated, which means that there's a finding that there's not enough evidence to support that there has been child abuse or neglect. And so administrative finding, there is no removal of the child or anything like that. That only happens through court actions. But an administrative finding is a final agency action. So it is a finding on the record. And it's significant a lot of times for, especially for people who are involved in education, nursing, daycare employees. They may be barred from employment if there is an administrative finding of a substantiation of child abuse or neglect. So that's an administrative finding. And then from there are cases and we come to the bottom, the smallest number of cases, where there's actually a formal court action where my office is involved in representing DHHS, and that DHHS is asking the court to take some sort of action, whether that's removing the child, placing the child somewhere, or whatever specific action, because the child is unsafe. So that's the smallest number of cases, and that's where everything that's where everything kind of funnels down into. And it's important to note that out of all of the cases, so there's however many thousands of reports of child abuse or neglect every year in the state of Maine, only a very small percentage of that ends up as some form of court action. So so maybe a funnel is an imperfect analogy, because some of it is filtered out. The cases are filtered out as the funnel gets narrower and narrower. And it's important to recognize that for each individual case, based on the facts, the amount of time that a case takes to go from a report of child abuse and neglect to court action, it could be, almost, 24 hours, right? It could be, depending on the investigation and the assessment, it could be very fast. Or, there could be large sections where DHHS may be involved with the family. There may be an ongoing investigation or assessment, but there hasn't been court action yet, or there may or may not be administrative findings yet. So it's not always it's not uniform necessarily in timelines for when every step happens. But just know that when there is an investigation or assessment based on a report of suspected child abuse or neglect, that DHHS does have some timelines in terms of when they have a turnaround to assess and investigate those matters, just to be timely and to make sure that children aren't at risk because we haven't had the time to investigate things. So just some additional terminology in terms of DHHS staff and DHHS district offices. There's a program administrator within OCFS, and they are the head of each OCFS at any of the 8 DHHS district offices. There's usually always at least one assistant program administrator. Sometimes there may be more than one. Then there are supervisors who supervise individual caseworkers, and each supervisor will have several caseworkers that they're responsible for, and they supervise the work. They kind of go through, they do regular updates with the caseworkers, and they're there to help make decisions and troubleshoot if there are issues with specific cases. And then the caseworkers themselves are the social workers doing the actual work of really going out and interacting with the families, interacting with staff, interacting with professional staff, whatever that may be. And it's important to recognize that within OCFS, there's a breakdown of how caseworkers are assigned. So CPS, or Child Protective Services caseworkers, are kind of, sometimes you may hear that they're referred to as assessment caseworkers. So they do that initial investigation or assessment, and they're typically involved in the very beginning of a case in investigating that initial report of abuse or neglect and the specific circumstances of the family. And usually a CPS worker will typically not be involved with a family as long. Sometimes it can be several months depending on the circumstances, but typically their involvement with a family is not as long. A permanency caseworker is someone where usually there's actually a court case and the children may be removed, or maybe the children are in the home with specific custody conditions or on the parents, things of that nature. So a permanency caseworker is involved with a family where DHHS is more actively involved, and their role is usually longer. And then we go to reunification, and a permanency caseworker is usually working with a family on how to reunify, how to alleviate the safety concerns that have caused DHHS to become involved. And so their role with the family may, doesn't always have to, but may stretch out longer for a period of months, and occasionally could be even, a year or more, depending on the facts of any specific cases. So that's the role of permanency caseworker. An adoption caseworker is pretty much exclusively working with children whose parental rights have been terminated, and they are working to have the children adopted by a foster home or relatives or whatever the most appropriate home may be. And then licensing caseworkers are caseworkers within OCFS who do the assessments for resource parents for foster homes and for relative placements for relatives who may be placement for children. So they are a separate kind of unit, and they do the licensing work for foster care. Licensing is kind of the general umbrella that falls under. And then additionally, there will be case aides and administrative support staff as well who help with just running the office and making sure everything works, transporting children, supervising some visitation if that needs to happen. So I just want to spend a little time talking about assessments as well, just in terms of when we're talking about those initial reports that come into that kind of intake, right? So intake is what we call the central office, where all of those reports by phone are coming in and they're being documented and screened. So when we say they're being screened, the assessment is going to be either be that the report is appropriate or inappropriate. So appropriate is what I was alluding to before, where there will be further investigation assessment by a caseworker, but in some of those cases could be referred to a community-based service agency as well. So a contract agency outside of DHHS where the reports are kind of less serious, where the threat may be reported threat is less serious. And then for those assessments that are deemed inappropriate, that there is not sufficient allegations for child abuse or neglect, those are just screened out, and that's kind of the end of DHHS involvement. Okay. And I want to spend a little time talking about mandatory reporters, and I see now that it is very unfortunate that so this is the full list of mandatory reporters. So people who have to report suspected child abuse or neglect. And I would note that number 31, which is conveniently hidden by my video screen there, is it states it's 31 is a family or domestic violence victim advocate. So everyone here on this list is a mandatory reporter, and they have to report suspected child abuse and neglect to that DHHS hotline. So just a few points on mandatory reporters. There has to be there are some specific instances as well. So for children younger than 6 months and children who are non-ambulatory, if there's fractures, substantial bruising, subdural hematoma, burns, poisoning, significant injuries for children, those have to be reported, generally speaking. There's also a requirement to report if a child is not living with a child's family, especially if it's been more than 6 months that a child has not been living with that child's family. And mandated reporters have to complete training. I apologize for that typo. It should be mandated reporters have to complete training once every 4 years. And you can use this website that I've attached here, which fortunately is not covered by my video window here, but you can use that website. So that'll take you to online certification where you can get, I believe, a certification that you have completed the training for mandated reporters. This video is not training for mandated reporters, and you can't use this video to say that you've done your training as a mandated reporter. So there's a specific separate training for mandated reporters in the state of Maine. And I just want to touch on this point as well. So in terms of confidentiality, there are a lot of specific laws, that we all deal with in terms of people may be familiar with HIPAA, with Part 2 for substance use records, things of that nature. But for anything that's related to child welfare and child protection, so DHHS records are confidential, and they're only subject to release in very specific and limited circumstances. So generally speaking, if you are participating at a family team meeting, or you are participating, you're at the home of an individual and it's a child protective matter and DHHS is involved, generally what happens is confidential, and DHHS records, in terms of written records, should not be disseminated. The contents of what happens at FTM, even aside from HIPAA and all various other specific confidential requirements, not that FTM is necessarily covered by HIPAA, but I'm just saying as an example, there are a lot of privacy concerns as well. But on top of that, child protection, child welfare has its own separate privacy and confidentiality statutes that are separate from all of the others as well. And it's very important to remember that court proceedings for child protective matters are closed to the public. And what you'll see with with our court proceedings in Maine District Court is that they're always a bench trial, which means that they are tried just before a single judge who is going to decide the case. So that means there's never a jury in our cases, that it's always just one judge who is hearing the evidence and deciding our cases. So we're going to go through kind of the specifics of what a legal case may look like. And sprinkled in here, we'll talk about not just necessarily the legal case, because there's a lot of legal details, and it's not so important to leave with every legal detail memorized, but also just to inform kind of how a legal case and the legal standard informs how DHHS makes its decisions, how DHHS is involved in families, even maybe before the court is involved, right? But in terms of court cases, these are the legal parties. So if there's an active court case, pretty much in every case, DHHS, Maine DHHS through OCFS is involved. The parents are involved. It may be biological parents. It could be de facto parents or some other form of parentage under the Maine Parentage Act, which has broadened the definition of parents to be outside of just biological parents. There is a guardian ad litem who is involved in all of our protective custody Title 22 cases. For ICWA cases involving Indian children, the Indian tribe will pretty much always be involved as well. And then there may be others who are designated by the court. And these are legal parties. So these are full parties to the case. These are parties who can call witnesses, who can ask the court to remove custody, to return custody. So it's hard to be a legal party to a case. All right. But aside from that, you have legal statuses for certain people, such as foster parents, relatives, who may be participated to observe court events or even participate in a limited manner. But they're not full interveners or full legal parties to the case. And so you may see some relatives in the courtroom, or providers for the child or the family, and they have a legal status that allows them to be there, maybe as an interested person, maybe as a participant, but they're not full legal parties to the case. They can't ask the court to do certain things. So it's important to, and I'll just touch on this briefly as well. Within the statute, there are the statutes under Title 22 are there for child safety and child protection. But within that framework, there are a lot of other considerations as well. We've touched on reunification briefly. So reunification is a key element for if children are removed, there is an emphasis that they should be reunified with family whenever possible. And DHHS has to make reasonable efforts. That's a phrase you may hear as well. Reasonable efforts to reunify. So DHHS has to make those reasonable efforts to try to reunify the family. And that may take the form of, doing referrals for case management, for counseling services, referral to domestic violence agencies, for shelters, what substance use, whatever level, or substance use evaluation. So reasonable efforts will vary depending on the specific case. But so if you hear about kind of services for a parent or things of that nature, the legal impetus for that is reasonable efforts to reunify, which is the duty of DHHS. But the parents or the caregivers also have a legal responsibility to participate in those services as well, and to use those services to alleviate kind of the safety issues. Additionally, as well, you may hear that there are other legal considerations for preference for placing children who are in state custody with siblings, or preferences for placing children in state custody with relatives of the legal parents. And so those are some, there are a lot of specifics about those examples, but just keep in mind that there are a lot of nuances about once a child is in DHHS custody or once DHHS is involved, there may be specific limitations or preferences on who the child is placed with. So you may hear about kind of those preferences and those nuances in legal cases as well. And that's something that is important to consider, that, even if there's not a legal case, everyone who's involved in child welfare kind of understands, well, okay, there's a general preference for sibling placements. There's a general preference for family placements. So even if, we're only talking about safety planning or the early cases, early involvement of a case, there is an emphasis on, family and those resources, because there's an understanding that, if there is a legal case, if there is a legal action in the future, there is this legal kind of preference for families and for sibling placements. And that's just one example of those types of things. So just in terms of a case timeline, and this goes back to kind of what we were talking about before with the funnel of all the reports that come in, right? So we have the reports that goes to an assessment, and then from those assessment, a filing of a petition is kind of what initiates court action. And if there is a court action, it'll be a preliminary protection order and a summary preliminary hearing. And these are only for emergency situations. These are for when the department is petitioning the court, and sometimes it can be after hour on the weekends, and we can't wait until the next business day, right? So there's an emergency situation. We've asked the police officer possibly to do a 6-hour hold until we can get a judge to review our emergency kind of petition, essentially, right? So if you're about PPO, preliminary protection order, or summary preliminary hearing, SPH, those are for those really urgent emergency situations. And then what you have is a jeopardy hearing, and that'll usually be 2, 3, sometimes maybe 4 months after the filing of the petition, when the department asks the court to do something. And that'll be the kind of the first formal hearing where the court gets to hear the allegations of abuse or neglect, and the court will decide, whether or not the children are at risk of further abuse or neglect, and what the court should do about it if the court does find that they are at that risk, right? And then from that point on, assuming that there is jeopardy, that there is ongoing DHHS involvement, then the case will be resolved through one of several means. So reunification is the preference in almost all cases. So that's where the services are provided, the family engages, the parents engage, and they've alleviated jeopardy. They've alleviated the safety concerns that caused DHHS to become involved, that caused the child to be unsafe in the home, and the child can return to the home. So that's the ideal circumstances. If that can't happen within a certain amount of time, and usually we're talking months and sometimes years, but if reunification is not happening and it doesn't look like it's likely to happen, then that's when there can be kind of guardianships or permanency guardianships, or even termination of parental rights as a way of achieving kind of permanency for children. So you hear this phrase a lot in child welfare and child protection, the concept of permanency, that it's children need permanency, and it's not good for children to kind of languish in child foster care, or not know who their family is, or not know who their long-term caregivers are going to be. So while still honoring the idea of constitutional rights of parents and their right to try to reunify with children, there is also a sometimes countervailing, but sometimes it can work in tandem, an urgency for permanency for children, to get permanency for children as soon as possible as well. So I just want to spend some time to talk about this case timeline, because even though my involvement in terms of I get involved after DHHS is filing a petition and asking the court to do something, that's a very small minority of overall cases when you're looking at the funnel and how the cases filter out. A lot of the cases are filtered out through the reports or the assessment phases and never reach the point where DHHS is becoming involved. So you may hear a phrase such as like a service case, right? You may hear that phrase thrown about. And what that means is a service case is where DHHS is involved, and it may be kind of like a long-term assessment is probably the easiest way to think about it, where DHHS is involved on more long-term and just kind of assessing the family. And it's not, the situation is not urgent enough that DHHS is asking the court to intervene to remove custody or, necessarily force, anyone to do anything. But, there's enough of a concern that DHHS is keeping a case open. There's a caseworker assigned to the family to, maybe help them with services, right? Or obtaining services to prevent the need to remove the children, or whatever that may look like for that specific case. So you may hear about services cases and these other various kinds of, there may be a safety plan or a plan for safety or things of that nature. And that just means that it may be before there's formal court action, but DHHS is still concerned enough that they want to be involved with this family, and that's largely voluntary, right? So that's not through court action. That doesn't have the force of law behind it necessarily, but it's working with families to try to avoid the need to take court action or to get to that point. And it's important to recognize, especially for me in our work, that while we're in court dealing with these cases, a lot of what I think providers and individuals may see in their day-to-day work are cases where there's an ongoing assessment or an ongoing service case, and there hasn't been court action yet, but there's that possibility, and DHHS may be involved or investigating or things of that nature. And I think it's important to recognize as well that in our line of work, both in the Attorney General's office and at OCFS, from all the caseworkers, supervisors I've interacted with, we all recognize that I think DHHS involvement in child welfare, child protective, is very incredibly disruptive to parents, to children, to families. Removal from caregivers can be traumatizing for children, can be very difficult for children. So I think it's important to recognize that having DHHS involved, and even in the assessment stage, even in service cases, even in safety planning or plans for safety, that it is for many of these families, it's an incredible stressor on them, that there's a lot of possible anxiety about the possibility of court cases and things of that nature, and it can be a large time commitment when we're talking about services for counseling, evaluations, parenting courses, whatever that may look like, and then if there's a court case, there's supervised visitation, there's transportation, there's a lot of these issues. So I think it's important to recognize that even though I'm not going to spend a lot of time talking about it in the specific legal terminology and legal framework and understanding the overall system, there are a lot of intangibles that happen between the caseworker and the parents or relatives and providers that consume an extraordinary amount of time and resources that judges and attorneys and other individuals we may not hear about, right? Or we may not fully understand, or we may not get to see all of that in that case. But for the parents and the caseworkers, that's the vast majority of their time. And for providers, the logistics may be just as difficult, whereas, as an attorney, we're focusing more on the specific legal requirements of child safety. But, a parent, a family, in terms of their meeting their day-to-day needs of paying the bills, paying for housing or things of that nature, those are all other considerations that they have to balance as well. And I think it's really important to recognize how kind of the child welfare system and the child protective system impacts all of that collectively, even though we're kind of exclusively focused on child safety. So just a quick point about guardians, guardian ad litem's. There are requirements on guardian ad litems in terms of when they have to have face-to-face contact with the child when they're first appointed, and their ability to have access to records, and their responsibility to update the courts on a timely basis. So we'll talk about the child protection kind of process within Maine District Court, just so that there's an understanding of what's actually happening at District Court. But then, I wanted to circle back on talking about some of the bigger principles for child welfare as well, in terms of why DHHS is involved. And I think the court kind of examples help to illustrate really the legal principles that underpin a lot of the work that DHHS does, even when there's no specific court involvement. So when we're talking about a petition for child protection order, this is something that's filed by DHHS alleging that there's a jeopardy, a risk of serious harm or neglect. So in the state of Maine and in several other states, this is called jeopardy. A lot of other states will again use the phrase dependency. That's something you may hear in several states as well. But in Maine, we call it jeopardy. So that's the risk of serious harm or neglect. And there will be a hearing, and oftentimes the parties may come to an agreement in terms of what the parents and DHHS will come to an agreement that, these are the issues. Maybe it's substance use, maybe it's domestic violence, maybe it's criminal activity, maybe it's physical abuse that cause the children to be at risk of serious harm or neglect. Okay. And then as a result of that, so from a petition, a preliminary protection order or PPO is an emergency request for that immediate transfer of DHHS custody. So again, there's that risk of the serious harm, but this time there's an allegation that it's immediate, that it's an exigent circumstance that really can't wait the several months for a hearing. Okay. And sometimes these are brought to the attention of the judge before the attorneys are appointed, and sometimes even outside of the presence of the parents, if that can't be arranged on an emergency basis. These are things that sometimes can happen in the middle of the night, right? And then a summary preliminary hearing, and again, there's a lot of legal terminology here. It's not important to memorize everything. The summary preliminary hearing is a hearing within 7 to 14 days after a preliminary protection order, where a parent has the right with legal counsel to contest the emergency removal, essentially, right? To contest whether or not there's immediate risk of serious harm. But a parent, may choose not to have this hearing, in which case they can waive their right to a summary preliminary hearing. I want to touch on one point briefly here, and that's just that final bullet. In terms of the aggravating factors, you may hear this phrase as well. So what I was talking about earlier is that reunification, generally speaking, reunification has to happen, but there are certain specific things that may be called aggravating factors, which are specific, sex crimes. This is an exhaustive list. Previous contested hearings on termination of parental rights, if the child has been abandoned by that parent. So there are specific things that doesn't always have to be, but that can be considered aggravating factor. And if there are certain aggravating factor, the court may determine that reunification is not appropriate. So that's a case where we have a cease reunification order, and that's in a very small percentage of cases. So that's why I don't want to spend too much time on it. So if you hear about aggravating factor or cease reunification, just understand that means there are specific factors that are particularly, if there's been a specific conviction for sexual abuse of a minor in the past by the parent or something like that. There are some specific factors. One of them is, if the parent has subjected the child to, if the parent's treatment of the child has been heinous or abhorrent, right? So that's kind of more of a general standard, but it's a high bar for an aggravating factor and a cease reunification. So it's not very common in the vast majority of cases. And then so PPO or SPH, those all deal with emergency petitions where there's an emergency allegations. And not every case that DHHS brings to court contains a PPO or SPH. So for all cases, regardless of whether there's an emergency petition or not, there will be a hearing on jeopardy. So this will be the hearing that's 2, 3, 4 months out from when the department initially files the petition, and that's where the court is weighing whether there's serious risk of harm or neglect. Right? Think back to the definition of abuse or neglect as well from from earlier on in this video. So, and again, oftentimes parents and DHHS and the GAL will be able to come to an agreement on, these are the specific issues that are making the child unsafe in the home that everyone has to work on. But if there's not an agreement, then that's when there's a hearing before the court and the court decides. And this has to happen within 120 days of when the department files the initial petition with the court. So I just want to touch on disposition for a bit as well. So disposition just refers to the power of the court in our Title 22 cases in terms of what the court can order. So the court can order that custody of the child be removed from the parent, that custody of the child be granted to DHHS, or that custody of the child be granted to a relative or third party. Separate from that, the court can make specific orders about the placement of the child. So for instance, the child may be in DHHS custody, but there may be a dispute about whether a child should be placed with one relative or another, or a relative versus foster care, depending on the specific facts of that case, right? So a court can order a specific placement of the child. The court can also order treatment or services for the parents, removal of a perpetrator or dangerous situation. The court can make orders of child support or modify existing orders of child support. Again, very limited subset of cases, but there may be some aggravating factors that could lead to a cease reunification. And if there is a cease reunification, it just accelerates the timeline for getting the child to permanency. That's something to consider as well. And other things that the court can order, in terms of visitation and things like that. There are a lot of kind of intangibles in these child custody circumstances that the court can order in terms of visitation and things of that nature as well. So just to touch on reunification. Yeah, reunification. So DHHS has to make reasonable efforts to reunify, to rehabilitate parents and reunify families and prevent removal of the children as well. So that's an important part. So in terms of reunification and reasonable efforts, even though earlier I talked about reasonable efforts in terms of reunification, there's also a duty on DHHS to make reasonable efforts to prevent the removal of the child in the first place. So even before there's court action, there's a duty on DHHS to make those reasonable efforts to try to prevent the need for court action to remove the child in the first place. So that's something to consider as well. So that's why, when there is a service case or DHHS is involved, everyone's working together to prevent the need to remove the children from the home, because I think we all recognize that ideally children do better with their own families. And then parents have an obligation to participate in those reasonable efforts. And then cease reunification just refers to those reasonable efforts. A cease reunification doesn't automatically mean termination of parental rights. Cease reunification doesn't automatically mean that visits will stop. So sometimes visits will still be happening, but it just means that those reasonable efforts to reunify, that responsibility is no longer on the department in those cease reunification cases. But again, very small subset of cases. So again, these are just some aggravating factors. I'm not going to spend a lot of time on this, but you can see that it's for more serious issues, rape, gross sexual assault, prostitution, torture, heinous or treatment that is heinous or abhorrent to society, abandonment, which is defined as lack of contact for 6 months, or something that indicates an intent to abandon the child, right? And then specific crimes for where the victim was a child. If the parent has been convicted of manslaughter, murder, felony assault, where the victim was a child. The last one, parental rights to a sibling, have been terminated. So these are just the aggravating factors. And then a cease. So a cease could be ordered based on aggravating factors. or that it's inconsistent with the permanency plan for the child. And this is all discretionary. So even if there is an aggravating factor, it doesn't guarantee that there'll be a cease of reunification. Okay, so the court will have to consider the individual facts of every case. If you hear about judicial review, so a judicial review is when a case is in court and needs to be reviewed at least every 6 months. Sometimes cases will be reviewed every 2 months, every 3 months, every 4 months, but at a minimum, it has to be every 6 months. And what the court is looking at is visitation or contact, reunification efforts, what the ongoing jeopardy or safety issues are, the appropriateness of the child's placement, and just generally, how is the case going? How is reunification going? How are the parents doing? What is permanency looking like for this child? How safe is the home? So it's an update on the case, and it's really designed to help keep these cases moving forward so that there is a resolution, a timely resolution for these children. And so during a judicial review, the court could alter the disposition in terms of who has custody, who has placement, and usually these are entered by agreement of the parent and DHHS, but if there's a disagreement, then we schedule it out for a contested hearing, and the court has to decide, if there's disagreement about placement or custody or visits, then the court will hear evidence and decide that issue. So typically what happens is a judicial review is scheduled for just a 15 or 30-minute block on a single day every month in each specific courthouse, and there'll be numerous, a dozen or sometimes more, sometimes less cases is scheduled for a single day, at those 15-minute or half-hour intervals. Okay, and so those are generally to put the agreement on the records and for the court to check in with the parties. If there is a contested hearing, generally speaking, that will be scheduled for another day later in the court schedule. A permanency planning hearing is often combined with a judicial review, and a permanency planning only has to happen every 12 months, but because they are combined with judicial reviews, generally speaking, they usually happen every 6 months anyways, and that's where the court is considering what the permanent plan is for the child and the reasonable efforts to finalize that permanent plan. And what the plan is for the child to reunify, to exit the system is, whether that's reunification with the parent. If that's not possible, then TPR or permanency guardianship, or it could be possible that the child is going to age out in foster care. One thing you may come across is there's a phrase when the child has entered foster care, and there are a lot of legal timelines that are attached to this that I'm not going to get into all the specifics, but it is just important to know that when the child has entered foster care, so when there's that first judicial finding of abuse and neglect, or 60 days after that emergency removal, whichever is sooner, that is the date that the child has considered to be entered foster care. And based on that, that's when the permanency and all of those issues from a legal standpoint kind of start ticking. And that's when the timeliness for permanency and getting the child out of the system in a safe manner is kind of initiated. So as an example, that last bullet point that's partially cut off, the department, if the child has been in DHHS custody, has entered foster care for 15 months, then generally the DHHS has to file a petition asking the court to terminate parental rights unless there's a compelling reason not to. So while there's no clear hard answers on 15 or 12 months for a TPR or how long a child can be in foster care, you can see that the statute places a burden on DHHS, at least for children who have been in care for 15 months, to generally have to ask the court for a TPR or document why there's a good reason not to do that. So there's no hard timelines on permanency necessarily, but you can definitely see that once we stop talking in terms of months and year and start moving into discussion of years, there's definitely a shift in emphasis that, okay, maybe reunification is not working, or something along those lines. That's not always the case, but that's where the consideration may be. So I just want to touch on this briefly, and I'm not going to spend a lot of time on this. So there's just termination of parental rights is final in Maine. It's the final severing of that legal connection between the parent and the child. The only thing is it doesn't disturb inheritance rights, but the parent essentially has no further say in any decisions regarding the child, is not entitled to any information about the child. They're informally, they may have some contact with the child if the child seeks them out, or if the adoptive or foster parent permits some kind of contact, or it may be appropriate for the child. There are those circumstances. So it's not that TPR necessarily means no further contact at all, but in terms of legal rights of a parent to a child, it does sever that completely. Okay. And I'm not going to spend too much on this, but in terms of the grounds for termination, termination is a high bar, legally speaking, because the constitutionally protected right of the parent to the child is being terminated. So there's a higher legal threshold for termination of parental rights. And parents can agree to terminate their rights voluntarily if there's a petition from DHS to ask them to terminate parental rights. And the court has to find by clear and convincing evidence. So everything we've talked about in terms of the court proceedings before has been preponderance of the evidence, which is 51%. But clear and convincing evidence is one step higher than that, but still below beyond a reasonable doubt, which is kind of the criminal standard. And what the court has to find by clear and convincing evidence is that the parent is first unfit, and then that termination is in the best interest of the child. So that's a two-part analysis. So unfitness is any one of these 4 prongs here. And as long as the court finds one of these unfitness prongs, the court can then consider best interest of the child. So the court has to find unfitness first. So again, not important to memorize every legal minutia, but it's just important to recognize that the court has to find that the parent is fundamentally unfit first before the court can consider whether or not it's in the best interest of the child, because we can't just go around and terminate parental rights just because it's in the best interest of the child. There has to be an element of unfitness first. So it's a 2-step process. But it's complicated by the fact that, realistically, in terms of on the ground, some of the facts that support parental unfitness may also support why it's in the best interest of the child to terminate parental rights. So there could be that overlap. But legally speaking, it's a 2-part analysis: unfitness of the parent, and then best interest of the child. Okay. So there are many factors that the court can consider in terms of best interest of the child. Bonding and attachment is a huge factor as well, but there are multiple, domestic violence is mentioned specifically in best interest determinations of the child as well. So there are a lot of factors that can be determined in terms of best interest of the child. And just in terms of post-termination review, so just be aware that even if there's a termination of parental rights, the court can still review a case still has to review the case every 6 months until the case is dismissed. So that means the child is adopted, or maybe the child has reached a certain age and has aged out of the system. But just the termination of parental rights is not the end of the child protective case, because the child still requires permanency. And so permanency is when the case will formally terminate, right? And that sometimes can be in the form of a guardianship to a relative or permanency guardian. But one thing that's generally understood is that, generally speaking, guardianships and whether it's permanency guardianship or sometimes it could be a probate guardianship, there are different types of legal guardianships. Guardianship is generally not as favored as adoption when reunification is not possible, just because guardianship is not as permanent, because it's a legal court order of some form ordering custody to a third party, but it can be disturbed. The parents could go back to the court and ask the court to reverse that order for whatever reason, right? So because of that, adoption is kind of generally favored as a permanency option when reunification is not possible in a timely fashion. Okay. So I want to spend a little time as well, just before we circle back to some of the broader points, about the Indian Child Welfare Act, so ICWA. And I do a lot of work with the tribe specifically on ICWA. So throughout the decades, and this is a good primer as well for kind of just the general sphere of child welfare, there has been a lot of problems with how child welfare laws have been applied, both by the courts and also by the actions of state agencies in removing children. There have historically been a lot of injustices in discriminations against tribal families for removal of children, when oftentimes it was a cultural a failure to understand cultural practices, or stereotypes against tribal members for substance use or things of that nature. So because of that, ICWA was enacted to provide higher requirements for the state to prove its case in removing Indian children. And there's a specific definition for Indian children in terms of who qualifies, the membership requirements or the citizenship requirements within certain tribes, federally recognized tribes in the United States. So it's important to recognize that ICWA applies to all federally recognized tribes. And even though the tribe is not legally a parent of the child, oftentimes conceptually it helps to think of the tribe as another parent of the child, who has rights to the child and who has a very specific and legal interest in the child as well, because ICWA does provide that. And it's important to note that OCFS makes special efforts through our policy and our work with the tribes, specifically located in Maine, to partner with them throughout the case, the duration of each case. Makes extra efforts to partner with tribes in Maine throughout the duration of each case. And that's really, so when we were talking about the case timeline, OCFS will, even during the assessment phase, reach out to their tribal counterparts and child welfare staff for each tribe, and really co-case manage. And what that means is work collaboratively in investigating safety concerns, and really make collaborative decisions about child safety in the community, and really try to prevent the need to remove the child. And so there are a lot of federally mandated higher standards for removal of children under ICWA, and that only applies to Indian children. But it's often been regarded as kind of the gold standard, that the state has a duty to make active efforts instead of reasonable efforts, right? So under ICWA, there's a requirement for active efforts to prevent removal and active efforts to reunify a child with that family. And that's really kind of a step above and beyond reasonable efforts. And that's really been described as kind of the gold standard of casework in terms of child welfare and child protection. That really, that's the standard that we should be ascribing for in all of our cases. And just some additional context about ICWA. Just in terms of Richard Henry Pratt, was this retired, I believe, colonel back in the 19th century. And I apologize again, the quote is cut off, but the full quote is, "Kill the Indian, save the man." And Richard Henry Pratt was really thought of as a progressive in his day, that it wasn't just, he thought that, that Indian culture was the problem and really had to be eradicated. And that was back in his time frame, some people thought that was a progressive mindset. And we see how deeply flawed it is today in these history of these reform schools. This isn't, especially in Canada with the recent with the recent revelation of kind of the mass graves and the and kind of the horrors that were happening in those reform schools as well. So the scale of kind of these reform schools and this really kind of cultural genocide. This is the Carlisle Indian Industrial School, Carlisle, Pennsylvania. It really, these were families that were just torn apart. And it could have been based on discrimination. It could have been based on failures to communicate, but it was really an abuse of the child welfare system. And it really serves as an important lesson that hopefully we're all taking to heart about why, even though we are all passionate about our work and child safety, we have to temper our passion with making sure that we are being fair, we're being considerate, empathetic, and we're being culturally understanding as well to what we don't know, what all of us don't know, because I think it's important to approach this work with humility as well, whether you're an attorney, a caseworker, a provider, a doctor, whoever you may be in terms of child welfare, that we recognize that there are a lot of people involved in all of these cases, that individuals come with their own expertise, their own worldviews, and most importantly, their own experiences as well. And that a lot of these families that we interact with, a lot of these individuals, they may have trauma, whether that's the form of generational, intergenerational, historic trauma, or specific trauma from whatever may have happened in their lives or the lives of those people around them. And so that's something that we have to be respectful of in our work in child welfare, that it's a very disruptive system. It can be a very traumatic system as well. There are countless stories of trauma from child welfare systems where the child welfare system has fallen short in terms of foster care placements or whatever the specific examples may be. And I think it's really important to recognize as we go forward in this work that when we look at these photos, at the time they were maybe accepted or even thought of as benevolent, that there was this very religious movement to reform these individuals into what was culturally acceptable at the time. And I think for many of those individuals, maybe those individuals thought that they were doing good work, or they were making a positive impact in the lives of these communities or these specific individuals, when that was not the case. So that's something that I think we have to approach our work with, and that I try to approach my work with, is an extreme amount of humility in terms of what we may not know. And it's really important to recognize as well that when we're talking about child safety, I think there can oftentimes be, and maybe tension is not the right word, but there's often a counterbalancing of child safety, and oftentimes we see instances where there are other concerns as well. Maybe it's a domestic violence situation involving one parent and the other parent, or it's a financial situation, or there are many other factors at play other than child safety. And sometimes the department is in the position of weighing, well, what is making these children safe or unsafe? And in terms of protective capacity, that's a phrase you'll hear a bit. Sometimes the department has to weigh whether or not a parent may or may not be taking protective capacity, sometimes from the other parent. And this most often comes up in kind of domestic violence cases, or in cases of physical abuse, where one parent is in denial about the other parent's role or their likelihood of having caused that physical abuse of the child, or things of that nature. And I think that's part of the ongoing education with DHHS. I think there has been a tremendous amount of education in terms of domestic violence and victims' rights and victim services We recognize there's a lot more work to be doing with all of our staff and everyone involved in this line of work. But I think it's important to recognize that we in the Attorney General's office, what I've seen with all of my caseworkers and supervisors and program administrators, even though our charge is child safety and that's why we're involved, we still are, we're all state employees. We all serve the people of Maine. That includes the parents, that includes relatives, that includes everyone involved in all of our cases. So even though we are charged with child safety and that's what we primarily care, that's what we emphasize in our work, we want to make sure that we make space for considering the safety of a parent, considering the parent's road to reunification, right? What does that mean in terms of their participation in services? Sobriety. There's been a lot of written in the literature about how sobriety can be a long journey with a lot of relapses, and that may not fit in well with the idea that children need permanency within 15 months, 12 months, or 18 months, whatever we may be talking about. So there's a lot of, we go to tension or counterbalancing. And I think in our line of work, we are trying to be understanding of a lot of these counterbalancing priorities. And especially for, cases where parent safety may be at risk, from whether it's another parent or a third party or whoever we're talking about, the department will take those steps to try to prevent sensitive information from being revealed. Or, if one parent is in a shelter or a DV shelter or something along those lines, we will work with providers. And we do understand the limitations on providers. If you guys or if providers can't testify or can't have to limit your involvement because of your priorities, your own privacy, and ethical considerations as well. So that's just something that we recognize as well. And finally, I just want to turn to, so this is my contact information. I would encourage anyone watching this to please reach out to me as well. I'm in the global system for state employees as well, if there are other state employees watching this. And so this has been a very generalized overview of the child protective system. There are a lot of specific nuances in terms of child welfare, how DHHS interacts with providers, how DHHS interacts with families. It's just important that I kind of pay respect to the fact that for us in the child welfare arena, attorneys, caseworkers who work intimately with families, we may take for granted that we have a case, a few cases every day involving different families, different removal of children, different placements of children, and children's custodies are changing, children's placements of are changing. And I think it's important to recognize that for those specific families, for those specific individuals, this is, possibly one of the more traumatic events in their lifetime, right? Or it could be a hugely significant event for them. But it may not. It's different for people for us who are involved in the work day to day, and I think that's something for us to be cognizant of as well. In that the work we do has a huge impact on these families and these individuals, and we are always looking for additional input on how we can improve, how we can learn, if there are additional facts, if there's additional literature or research that can be brought to our attention that helps us better understand family, children's, and how to better serve. Ultimately, that's what we're about. We're serving the people, the citizens of the state of Maine. And we do that by protecting children, but we interject ourselves into these families, into these dynamics, and any information that anyone has, I implore you to reach out to me, to reach out to our office, to OCFS, We are always looking for additional avenues for improvement, for education, for training, and on the same side, we're always seeking to improve education and training about our work as well, in terms of how we do our work, how we interface with other agencies, with other providers, with other professionals, and other ways to collaborate. So with that, hopefully this has been a helpful kind of primer on child welfare and the child protective system in the state of Maine. And please do reach out to me if there are any further questions or if you have any thoughts or comments about this video. Thank you very much.